pledge allegiance to the flag
Morning.
of the United States of America.
Morning.
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. And then
We got
Barry,
Eric back.
Yeah, Barry, I'll do my quick little safety talk.
Yeah.
Okay. Well, just a reminder, the 4 rules of gun safety, and I stress this a lot. The gun is always loaded, and never point the gun at something you don't want to destroy. I'm just going to stick to number 1 and 2 right now. This month I was in a competition, and there was a safe table. A safe table is where you can take your gun out of the holster, or either out of the holster, put it back in your box, take it out of the box, check it, turn on a red dot, work the slide, do some dry fire if necessary, but no ammunition is there. Okay, so no ammunition is anywhere around the safe table. There are about 3 of us at the 6-foot-long safe table, and I was on the far left. In the middle and to the right were a couple fellows just kind of joking, talking, having a good time, and some other people surrounding. At one point there, the fellow in the middle, in working his handgun, was pointing it right at me. I just backed up, raised my hand to go, whoa. If there was a safety officer, this was before the competition began, he would have been sent home for the day. Yes, all guns are always loaded. It was supposed to be a safe table. I'm assuming it was not loaded, but never point the gun at something you don't want to destroy. And, you know, these are experienced shooters. I've seen this fellow there many times. So just keep the safety rules in mind. And that's all I got to say about that.
Thank you, Larry. You want to give a treasurer's report, Tony?
Yes, we have 136 members, and we have $2,045 in the Treasury.
2045?
Yes,
Did we find that $10 yet?
yes, we did. She called me yesterday and deducted or put it back in.
Oh, she did? So she had the money?
Yeah, she was using it for Christmas shopping, I guess, or something. I don't know.
Yeah, maybe a tip.
It's a Zoom call.
What's this?
The shooting club.
All right. The only thing I want to mention is, you know, we have ongoing training going, and the next one is December 19th, which is this Saturday, which is dim light course. And Larry and I have taken this course a couple of times. It's a really good course. It's I think it's $45, if I'm not mistaken. But if you're ever going to have any problems with home defense or personal defense, most likely it's going to be in the dark. So that's why this class is excellent class. So I would highly recommend this class for you to take some time. And it is limited as far as when he can offer it, because he only does it, you know, after it gets dark, because we can't do a dim light class in the light. So he always does it. Is this daylight savings time, or this is Eastern Standard Time, aren't we?
Eastern Standard Time.
Anyway, he only does it this time of year. He only does it this time of year because of that, because it gets dark around 5:30. So you don't have to be out there till midnight taking this class. With that, I'd like to introduce Kevin Sona. Did I pronounce your last name, Kevin?
Correct.
And Eric Friday, and they're from Florida Carry Incorporated. And they're going to talk to us about, I don't know who wants to talk first, but either one of you can go. Kevin, you would like to go first?
Sure, I can go first. We are an all-volunteer organization. We are statewide. We work with the national organizations such as SAF, Second Amendment Foundation, along with Gun Owners of America. We've done stuff with the NRA as well. Like I was saying, we broke up the state into regions to better serve our members. We have tons of members throughout the state of Florida. So we broke up the state of Florida into 11 regions. So we're up the Panhandle all the way down to the Keys in between. Right now, where you guys are in Region 5. So there's 5 counties part of Region 5, which is Marion, Summit, Citrus, along with Hernando counties. But we do work all over the state of Florida. We help members all over. We are very, very active in the civil rights, in the gun laws. We have registered lobbyists in Eric Friday. We've helped write legislation and bills that have passed, such as Florida's preemption statutes. So we're active in any way we possibly we can. There's a lot of things we do that are not public knowledge, because a lot of times things occur and we get things settled, and individuals don't want to either make them public. But we're active every single day, and this is something Eric and I are very, very passionate about, and I'll field any questions you guys have.
Well, you want to tell us about your camping event?
Sure.
Because we're recording now.
Okay. Yeah, we run this is our 4th annual camping event. It started off 4 years ago just as a fellowship of our members and our board of directors, our leadership, that just get together and have fun with their families. And it turned into something totally out of my realm of possibilities. And somehow it's gained traction into a community where Second Amendment activists, advocates from all over the country want to be a part of this. So on March, if individuals don't want to camp with us, March 19th through the 21st at Ross Prairie State Campground, they can come out Saturday, March 20th for our speaker event portion. So we're going to have 11 guest speakers, firearms experts, attorneys from Florida and out of state, civil rights activists. We will be set up for everything you can imagine. You don't have to bring anything. You may have to bring a chair. I'm working on some details yet, but all food, all drinks are free of charge. All you have to do is show up.
So what's on the menu? So I'll let you know if I'm going to come or not.
The menu for the event will be hot dogs, hamburgers, water, and I think chips are going to be there.
Okay, I can do hamburgers.
Yeah, we're set pretty good.
Uh,
I would like to add one thing though. A lot of the food will be donated by the firearms firm out of Orlando, which is David Katz and James Phillips from Katz and Phillips Law Firm. The last few years they've donated to help fund this event with food wise, and it's been an absolute blessing for us. So I appreciate everything Katz and Phillips has been doing.
Yeah, I have a video with them on first date at 1 o'clock today. If I another Zoom event, so they have weekly events. I don't know if you guys are all familiar. Those of you who are in U.S. Law Shield, they're sponsoring it, and then Katz and Phillips puts these presentations on, and this one today is on first aid.
Yep.
They're all good, and this is probably going to be good as well.
Florida Carry, we have partnered with U.S. Law Shield. David Katz and James Phillips, they do some of our litigation work for us as well, along with all with Eric Friday's blessings and guidance, I guess. But Katz and Phillips and U.S. Law Shield are two great organizations. If you're a concealed carry holder, I highly recommend. If you're a gun owner, if you have homeowners insurance, you protect your home. You have car insurance to protect your vehicle. Why not have self-defense insurance to protect the situation? Because Eric can definitely dive into that better than I can. That gets extremely expensive really fast.
Yes, it does. Their training videos, like I said, is really good, and this is going to be the last one of the season. They're going to start them back up in January again, I believe. And I think I just got a email that said when the dates are and stuff, but I probably would watch them 2 or 3 times because they're that good.
They really are
very informative. I had another question, but I can't remember what it was. Oh, I know what it was. Will you be sending us some information or send me some information on this camping event so that we can round up the troops and see who wants to go?
Absolutely. I will email that to you. I set up a Facebook event on it. We are Florida Carry is redoing our website. We hope our website is up and running completely new by the first of the year, and we'll have all the information on the website as well. So basically, the first of the year, we have 3 months to really pound the ground and get as many people as possible in attendance.
Well, last time you did it, I know you required, only because you need to know how much food to get, you wanted to get reservations or an idea how many people are coming and stuff like that. Will we be doing that again?
That's basically where I use the Facebook event thing. That's one of the main reasons I kind of do that. Which was cool about that is we're setting up that morning last year, and more people are piling in. I think we had 350 hamburgers and 400 hot dogs ready to go. And I looked at Dave and I was like, "Ooh, I hope we have enough." He's like, I know where Sam's Club is. So if we have to, we can always flee back to Sam's Club for more food.
Did you run out or did you have enough?
We had enough. We actually had enough to actually cook some hamburgers up that evening. So and you guys are welcome to join us after the fact back at the campground. That's where we have the real good shindig. We plan on doing fried turkeys and all kinds of other stuff Saturday night at the campground.
I don't have to bring an RV, do I?
No, you don't even have to camp. You can just come out.
Okay. I put your website on the invitation to this. But it's going to change, or it's going to be the same website, but it'll just have different information?
It's just going to be updated.
Okay.
Same exact website. It'll just be updated.
Okay. Because it's got an opportunity to join you on there. So
Yep.
If you're so interested, they do good work. And so, I think what you do is a bonus for Florida.
Basically, our camping event, our fishing events, our eat and greets, as we call them, where we just go out to a restaurant, meet with our members. They're based off. We basically have 3 main goals with Florida Carry. That's education, legislation, and litigation. That's our least favorite thing we like to do. That's why we have Eric Friday to handle that, and Eric does a fine job with that. But education is our primary goal, and that's to educate all our members and non-members of what their rights are. Rights from dealing with law enforcement on a traffic stop, to their rights if they are open carrying and they're engaged in hunting, fishing, camping, or out target shooting at the range. So just kind of know what they need to do.
So that leads me to my next question. Then you don't have to be a Florida Carry member to come to this camping event.
No, absolutely not. Absolutely not.
Okay. Good to know. Yep. Eric, you want to step in?
Sure. Thank you all for inviting us. I love doing these kinds of things because invariably I'm sure I will start getting some questions about, well, I've heard this from law enforcement, or one lawyer or one trainer told me this answer. Unfortunately, the information out there is very replete with bad information, bad knowledge of the laws. And we encounter that on a daily basis. Just to give an example, we had one situation where a person was openly carrying while fishing, and the city or the police officers for that sheriff's department for that jurisdiction said, well, there's a city ordinance that says no fishing here. Well, just like firearms laws, the state has preempted fishing regulations throughout the state too. So that city wasn't even allowed to have that ordinance. And we quickly got on the phone with the city attorney, explained that reality to him, and he said, gosh, you're right. Y'all let him go. And oh, by the way, go get rid of that trespass warning you just gave the guy, because he wasn't trespassing. He was there completely legally and lawfully, and we messed up. And you know what? That city's not getting sued by Florida Carry because that attorney in that city had the good sense when I sent him case law and said, here's the law that says you're wrong or your officers are wrong. He said, gosh, we're wrong and we're done. And that's our goal. That's really what we hope for. As I tell people all the time, I'm not looking for business. I don't need to go look for business. I haven't needed to go look for business in about 2 years. Unfortunately, there's a lot of people who are willing to give me business because they just don't want to follow Florida law. Currently, that includes the Department of Agriculture, the people that issue our concealed carry licenses. That also includes FDLE, the people who are supposed to be approving our gun purchases within 3 working days. And they just refuse to do it. I don't know if y'all are aware of this, but we have people who have been in what's called a decision pending status for over a year now. This was part of the Marjorie Stoneman Douglas bill that was passed after the Parkland incident. FDLE made a very creative interpretation of what the legislature passed and decided that they no longer had to comply with the federal law that says they have to issue a decision on background checks within 3 business days, nor did they have any obligation to comply with Florida law, which requires them to issue a decision within 24 working hours, which is defined as 8 to 5, Monday through Friday. In other words, the working hour is a 9-hour day with no lunch break. So FDLE decided they can put people in an indefinite decision pending status. One of these people includes service members. We also have a service member case where FDLE claims that the state of New York told them that despite the person being in the United States Navy, despite the fact that that United States Navy service member has a top secret security clearance to work on Seahawk helicopters, which is the Navy's version of the Black Hawk, and despite the fact that the Navy says he's authorized to carry a firearm in defense of this country and while providing base security, FDLE claims that it knows better and that this man is a prohibited person and is not allowed to own, possess, or carry a firearm. And so the reason for this decision, they claim, is, well, the new state of New York told the NICS system, which is the federal background list, New York told the NICS system that once upon a time, years ago, this person was committed to a mental institution. And when we were having the oral argument before the Court of Appeals, the chief judge of the court of that panel, who happens to be a West Point grad, asked the attorney for the Attorney General's office. So this is one of Miss Ashley Moody's employees. Said, well, where is the evidence? Show me something from the state of New York that says this man was adjudicated and committed to a mental institution. Where is it in the record? Well, Your Honor, we don't have it in the record. Okay, so do you have it back at your office or something? Well, no, New York can't give us New York law protects the mental health record, and so they can't give it to NICS, and NICS can't give it to us. And the judge's like, well, you understand if you made a similar argument in a trial court, you can be disbarred for that, right? Without claiming people have felony convictions without having evidence. That's something that an attorney can be disbarred for. And he didn't really have an answer for that. So we're awaiting a decision on that case right now. But these are just the examples of things we're up against with state agencies that believe that they have the right and the ability to ignore Florida law, ignore federal law, and just do what they wish because, well, somebody appointed them to the position or somebody elected them to the position. And unfortunately, that includes our supposedly pro-gun Attorney General, Ashley Moody, who is not taking any action to stop these type of things.
You don't think she's pro-gun?
Well, I know that when she was running for election, I spent several hours socializing in her conference room at the Florida Republican Sunshine Summit. I know that she talked a good game. I know that she made certain commitments and promises about her pro-gun credentials. And I'm very careful when I criticize our Attorney General because, as an example, the 18 to 21-year-old prohibition lawsuit that the NRA has filed. Miss Moody has an obligation under the Florida Constitution, whether she appreciates, approves, or likes a law or not. She has an obligation under Florida law to defend the statute that the legislature wrote, whether she likes it or not. And to the extent that she's performing her job, you will never hear me criticize her or any other person who is doing the job that they are appointed to do or elected to do under the constitutions of the state of Florida. But when she goes beyond her constitutional obligation and adopts a state agency's opinion of what the law says rather than what it says, now I think she's gone over the line. When she fails to discipline an attorney in her office who makes a frivolous statement to a court of appeals in this state, I think she's gone over the line. Or as she did in the 18 to 20-year-old case last week, when she tries to have an expert on mouse brains, I'm not kidding about this, the NRA sent out an alert about it, an expert on mouse brains, a neurologist or some type of neurology specialist doctor, they're wanting him to be able to testify in court that based on his study of mouse brains, 18, 19, and 20-year-olds do not have developed enough brains to be allowed to possess a firearm. Now, or not to possess, I misspoke, to purchase a firearm. But that's what the Parkland bill did. It said if you're 18, 19, or 20, you can no longer purchase a firearm in the state. So, we have, the legislature did put an exception in there for service members, but if a service member is 18 or is somehow the signing of a service member obligation make you more mentally developed, it may make you a better patriot. It may make you a person who should obtain extra recognition for your service and for your commitment to defending this country, but it in no way says your brain is better developed or somehow different than other people who do not choose to do that obligation in terms of how responsible or whether or not you can competently operate a firearm to defend yourself or your family.
Wasn't it Nancy Pelosi that said anybody that was ever in the service has got mental problems?
She did make that comment, and I anticipate one of the things we're going to see out of the Biden administration is an attempt to reinstitute something that the Obama administration put in place. And what the Obama administration did is there are a lot of service members who have mental health issues as a result of their service.
You mean PST?
Not necessarily. Usually it is a result of what are called TBIs, traumatic brain injuries. Traumatic brain injuries can affect they can affect very discrete components of the brain without affecting others. So a lot of service members, because of traumatic brain injuries, concussion from IEDs, that type of things, lose the ability to do math well. Therefore, they can't balance their own checkbook. Okay, they can still function in many ways as a very functional adult, perform most daily activities, but they can't necessarily balance their checkbook well. And so there's a process to have their VA benefits, distributed to the name of their wife or their child or a parent who manages their finances for them. Well, under the Obama administration, if you asked for that service from the VA was treating that as a automatic mental health status and putting you as a mental defective on the no purchase list, which meant no purchase, no possession, and no concealed carry license. Now, Trump rolled that back, but I anticipate seeing Biden reintroduce it. And that's an executive thing. That's not something that he needs Congress or needs the Republican Senate to approve. He can just do it. And that's one of my big concerns is we're going to see those type of administrative actions under a Biden administration, even if we do hold the Senate, even if pro-gun votes hold the Senate based on the Georgia elections.
I certainly hope so.
I hope Georgia does too. But
I read an article this morning that says this election is not over, even though the media would like you to believe it is, that they're all looking at January 6th because it may go to the Congress, possibly.
Well, people forget that in 2017, when it was time for the Senate to open the electoral votes electing Trump as president, that several Democrats did push for a disqualification of the Electoral College, which would have thrown it to the House and then to the House and the Senate to make the decision. Truthfully, I don't see that as a realistic possibility this time either. While I think there might be a few Republican senators who might do that, I don't see the entire Senate, Republican Senate, side of the Senate, which is what it would take. I don't see them, the whole group voting to disqualify the Electoral College. So
I don't think it's
that's
electoral
personal
college. They're
legal,
talking
not
about the
legal.
House. They're talking about the House.
Well, the only way it goes to the House is, and this is, election law is not my specialty, but if I remember my Constitution right, it only goes to the House if the Senate votes to disqualify the Electoral College or refuses to certify the Electoral College.
It could be.
So, and I don't see the Senate disqualifying the Electoral College. I don't think their votes are there for that, but that's my personal impression at this point. Would I love to be wrong? Well, you know, I'd like to, I'd hope that there was something to stop what I'm afraid is going to happen, but I don't really see it as a realistic thing at this point.
Yeah, so basically what they've decided, I guess, is that it's okay to cheat and lie in an election now and have a president that has dementia.
Well, I don't think he's going to be president that long, so.
I don't think so. When he leaves, it's going to get worse.
Yes, sir. It absolutely will. Ms. Harris's actions as Attorney General of California and the approved firearm list in California of what you can own is, I think it's going to be a model for what they're going to do in Washington. I like to make the comments, especially when I'm meeting with journalists, doing interviews with journalists. I said, they'll question, well, don't you believe in background checks? You know what? Absolutely. When did you get yours to get your journalist permission slip? When did you go through a background check in order to exercise your First Amendment right to be a journalist and to report on the news? And you know what? We might need to make sure that if you're ever arrested, that we take that permission slip back while we wait on the courts to decide whether or not you get to continue being a journalist. Because in my mind, there is no difference between the First and Second Amendment. And that's been a big bone of contention in some of the cases coming up, as the courts are refusing to apply well-established First Amendment doctrines to the Second Amendment. Justice Thomas has called this treating the Second Amendment as a disfavored right or a second-class right. Mm-hmm. And that's not, I don't know how you get there. I mean, maybe if one is more important than two, then two is more important than three, and three is more important than four. Okay, if that's the way we do legal analysis now, maybe we just need to cut the Bill of Rights off around the Fifth Amendment, because maybe if it wasn't enough priority for 1 through 5, it doesn't need to be in there. We don't need to worry about it anymore. But I don't think that's the way the framers intended the Bill of Rights to apply. So, Justice Barrett, Amy Coney Barrett, has made a distinction, and I think this is a valid distinction between the various Bill of Rights provisions, that certain rights are what are called civic rights, those being the right to serve on a jury, the right to vote. Those are civic rights, as opposed to individual rights, such as the right of free speech, the right to be secure from unreasonable searches and seizures, the right not to have to testify against yourself, and the right to bear arms. She made that distinction in a case where she said, just because a person's a felon doesn't mean that they should lose the right to bear arms for the rest of their life. What about somebody that's crime is not reporting all of their income? What about somebody whose crime is some type of tax evasion with tax fraud on their deductions? Because I can promise you, even the best accountant in the world who tries to be the most honest accountant in the world probably made an error in his taxes somewhere that could get him a felony conviction if anybody ever really pushed him. So it's a dangerous principle that they want to treat the Second Amendment in this way, because there's a site out there called 5 Felonies a Day that says most of us commit 5 felonies a day, whether we realize it or not. Mm.
Now, Eric, we still have the background check fee.
Yes.
Case active. That's something I wanted to talk to these gentlemen about. So, because I would imagine they purchased firearms in the last year, 2 years, 3 years.
So I'll talk about that. So Katz and Phillips, who with U.S. Law Shield, thank God they've come on because they have been a blessing to me, co-counseling with me they're my co-counsel on the decision pending case, and they're taking the lead, and I'm co-counseling for them on the fee case, the FDLE fee case. If y'all would, hopefully the ATF's not watching, or may have already lost a boating accident, but how many of you have a concealed carry license and have bought a gun in the last 5 years?
Everybody.
Okay. I am betting you paid your dealer a $5 fee to be sent to FDLE to pay for your background check.
Right.
That was an illegal fee. Next, so by Florida law, FDLE actually performs 2 background checks when you purchase a firearm. They perform a state check, and they perform a Brady Act NICS check. Okay, and these are 2 distinct checks. And the reason they're distinct is the NICS system was designed and created as a free system. No state is allowed to charge or is supposed to be charging for a NICS check. In fact, NICS sends FDLE money to process the NICS check. Our Florida licenses do not qualify us to avoid the NICS check like some states do. However, we also have the Florida check, and by Florida law, FDLE is allowed to charge $5 for the Florida check. But they're not allowed to perform that check if you are a concealed carry holder, if you are a police officer. They're not allowed to do the check, which means they're not allowed to do the $5 fee either. And so we have a class action lawsuit. By the way, FDLE takes in about roughly $5 million a year, most years, average over the past 5, for that check. So if we guess that maybe half the people who buy a gun in a given year are concealed carry licensees, well, that's 2.5 million. Or maybe it's only 1/5 of all gun purchases in Florida in a given year are concealed carry holders. Well, that's $1 million a year that they're taking in, putting into their budget, and they're not allowed to. They're not supposed to even get that money. So we're suing to get that money back. We're suing for them to have to pay everybody that money back and to pay the attorney's fees for us having to do this. So if you have not, the website for that is fdlelawsuit.com. The website is maintained by Florida Carry. Florida Carry is assisting in collecting this information because they are one of the plaintiffs in the case on behalf of members who don't sign up because they don't become aware of it. But if you go to that website, there are a list of questions you can answer that will, because that case is, or that website's actually for the 2 cases. It's for the decision pending case, and it is for the background check fee case. And what we're doing is when you answer the questions, it will categorize you whether you qualify for one or both cases, and then properly send you the right retainer agreement to become a member of the potential class that we are hoping to have certified this coming year for those 2 cases. So if you have any questions about that, I can tell you, I can answer them, but I can tell you, you are not obligated to pay anything for the case by joining and signing a retainer agreement. Florida Carry is handling all of the costs, so the court reporter fees, the filing fees, the travel expenses that I have, all of those type things. Florida Carry is handling those. You're either going to get money or you're not going to get money, and that's all that's going to happen. And we hope to change the law and make FDLE actually follow the law. The court will have a couple of options instead. If we prevail, which I'm very confident we will prevail eventually, it's just a matter of time. The court will have 2 options. They can either tell FDLE to give everybody their $5 back, or they can tell FDLE to give everybody $4.50 back and give me 50 cents a person. My goal is I want everybody to get their $5 back and FDLE to have to pay me separately. But if they don't do that, if the court says it has to come out of the settlement, well, I'll get as many people as much money as I can back, and I'll take a fee for my work, but it'll all come out of FDLE's pocket not any client's pocket. Other than maybe part of their refund. And I hope to avoid that because I don't think that's right either. So that's a big case we're working on. Katz and Phillips, like I said, is taking the lead. They're doing excellent work. Unfortunately, COVID has slowed every legal case in the state down. I've got a DUI that's now been going on more than a year because of the difficulties with courts and hearings and video hearings. So it's complicated. Kevin did mention U.S. Law Shield. I will second U.S. Law Shield as one of the best programs for in terms of protecting yourself if you ever have to use a firearm in self-defense. Another program that I give very high marks to is Armed Citizens Legal Defense Network, ACLDN, out of Washington State. The programs operate differently. They cover such a situation differently. For example, ACLDN only has a very small amount that they will pay out up front until their board of directors reviews and decides whether or not they're going to cover your situation. And it's not insurance. They're not licensed as an insurance agency. They're not regulated as an insurance agency. U.S. Law Shield is. But there are different plans for different purposes. There are caps on ACL's coverage. There are not caps on ACLDN's coverage. Marty Hayes, the director of that program, says that if it's a case they believe in, they'll spend every dime they've got in the plan to defend it. Does anybody have any idea how much George Zimmerman's defense costs?
Who did you say?
George Zimmerman. The Trayvon Martin case, his defense cost over $2 million. The average starting retainer for a self-defense case is $50,000 if there's a body on the ground, and sometimes even if there's not a body on the ground, it starts at $50,000. It just takes that much work. These cases last for 4 or 5 years very commonly, and that's without COVID causing problems. We were successful because of a case I lost, actually. I had a case out of Orlando, the Bretherick case. I lost it at the Supreme Court because at the time we had a very different Supreme Court than we have today in Florida. But I got a great dissent from Justices Canady and Polston. And based on their dissent, it took the legislature 2 years to fix it. But the legislature came back and said the Supreme Court was wrong. We never intended the burden of proof to be on a defendant who had to act in self-defense. And they shifted the burden back to the state where it belonged. Hey, state, if you think somebody didn't act in self-defense, it's your job to prove it. And if you can't prove it by clear and convincing evidence, you don't get to go to trial and put somebody in front of a jury and put them at risk of their freedom for the rest of their life. And sometimes the fact is we do lose cases. We lose them sometimes because judges aren't willing to follow the law. We lose them because the law is not clearly written enough. We lose them because of creative interpretations that judges decide to adopt sometimes. But when that happens, our next step is we go back to the legislature and say, hey guys, ladies, is this what you intended? Did you intend for this result to happen? And we've had some success. Used to, if you pointed a gun at somebody in a situation where you were being attacked, and just by pointing a gun at them, the situation was over, we were seeing a lot of people prosecuted for aggravated assault in those cases. So here's the deal, guys. You've been charged with aggravated assault. Your choices are accept a plea deal and plead guilty to something where you know you did nothing wrong, but take the risk that the jury doesn't agree with you. And if the jury agrees that you did something wrong, you're going to jail for 3 years, minimum mandatory, no way out of it. The judge has no discretion. You're going to jail. Oh, and if you fired that gun to scare them off, that's 10 years, minimum mandatory. And the state prosecutors were using that law as leverage to punish law-abiding gun owners because they had to defend themselves. And as I always like to tell the prosecutors, my guy had to defend himself because you didn't do a good job of keeping the guy in jail after his 5th or 10th or 20th arrest. So maybe if you'd kept the guy in jail where he belonged, maybe if you'd done your job in the first instance, instead of pleading him down, you wouldn't be having to talk to me about a plea bargain for my client. They don't like it when I say that very, very nice, very well, but sometimes it has to be said. I had a prosecutor tell me one time, asked me about, we were standing in the courthouse hallway, and he asked me, did I believe that a single punch could justify shooting somebody? And I said, yeah, even if he doesn't connect, even if he doesn't hit the person, yes, a single punch is a justifiable reason for somebody to pull a gun and use it. And here's why I say that. I'm gonna, I don't want to pick on anybody, but some of us are older than others. My dad likes to use the phrase, I'm too old to run and too young to take a butt whooping. But the fact is, knocking somebody of a certain age down can be a life-ending consequence. Most people over the age of 65, if they fall and end up in a nursing home, their life expectancy is now 6 months. So now, is that great bodily harm when somebody punches you if it's going to knock you down? Absolutely. That meets the legal definition of great bodily harm, and it justifies a deadly force response.
That would be disparity of force, wouldn't it?
Well, it would be a disparity of force argument as well, yes. But in Florida, if you attack somebody over a certain age, and I believe it's 65, it automatically converts the battery from a misdemeanor to a felony just by that fact. And that makes it a forcible felony. One of the cases that I've been trying to follow very closely, I can't remember the name of the parties to it, but it's commonly referred to as the Tampa movie theater popcorn shooting. One of the gentlemen who shot was a former police officer. And the fact is that they're trained that distraction techniques, like things being thrown at you, can cause you to miss the gun that's coming out at the same time. And so when he got popcorn thrown at him, he reacted in the way he was trained. And from everything I've seen on that video, did he handle it the best way? Probably not. Should he have probably handled certain parts of it differently? Yes. But when a younger, stronger, bigger person turns around and throws something at you, this is a situation, like I tell my kids, keep your hands to yourself. That includes your popcorn too. You start throwing things at people, you might get a reaction you didn't expect.
Is that case still in court?
That case is still in court. It is not resolved yet. I believe I can't remember if they had the immunity hearing. I think they did. I think the judge denied immunity, and I believe it's currently on appeal. I just don't remember exactly because I haven't been able to follow it as closely lately. And there's been so much, like I said, slowdown and chaos from COVID, trying to keep the machinery of justice as it is grinding away, that I'm just not sure what the status of that one is.
Anybody have a question of either Kevin or Eric? Because I got a couple more, but I don't want to monopolize.
Yeah, this is Larry here. I was just wondering either one of you to answer. Before we go to a firearm, we might be using pepper spray. Are there any cases, laws, worries coming up because of pepper spray use?
Well, I can tell you the use of pepper spray is a battery. I mean, if you pepper spray somebody, you committed battery. That may be a legally justifiable battery, but it's a battery. And so the same laws regarding self-defense apply. The difference is pepper spray is presumptively not deadly. But I can give you an example of a gentleman that did use a shotgun loaded with pepper rounds as part of his job, and he was properly certified as a licensed security guard in the state of Florida. He used that shotgun loaded with pepper balls. He missed. Person was in a vehicle. He missed shooting at the door with the hope of spraying the pepper into the person's face. And instead, the ball actually hit the person in their eye and blinded him. So now we've got felony battery for great bodily harm. Permanent injury was caused. He was eventually found to be immune from prosecution based on stand your ground. But that item, that shotgun was still a firearm. So he still used a firearm. He used it in a non-deadly force way, but there's no distinction in the law for what kind of ammunition's in the shotgun. So it was still treated as if he had shot a bullet. But back to more commonly handheld pepper spray. Yes, it is still a battery, but you are using non-lethal force. One of the things I like to explain to people a lot of times, they say, well, you can't chase a bad guy down to get your wallet back after he takes it. Well, actually, you can. You can't shoot him for taking your wallet, but you can make sure chase him down. You can't chase down and shoot the guy that was breaking into your car when you walk outside, but you can chase him down and get your property back as long as you use non-deadly force to recover your property. The common problem that happens is you're chasing the guy down, your gun's in your holster, you're chasing him down, he's carrying your wallet that you left in the car, and he turns around and decides he's going to fight you. But you are privileged in chasing him to use non-deadly force, but now he turns around and wants to fight you, and he goes and tries to grab your gun. Well, now it's become a deadly force encounter, and legally you're in the right. The problem is the prosecutor will argue, if they're not a believer in self-defense, what the prosecutor is going to argue is, well, you took a gun to a fist fight, and so it's your fault the gun was there, and therefore you have no right to use that gun even though he was trying to take it away from you. And that's the argument you're going to get. And unfortunately, there are a lot of judges that are going to buy that argument and say, well, you're using deadly force in defense of property. But the law clearly allows you to use non-deadly force in defense of property. So if you have to chase them down and beat on them a little bit to get your property back, as long as you don't escalate it to deadly force, you're allowed to do that. It's probably not the best idea, probably not something you should do, but legally it's within the law.
I get a lot of people that tell me that, the best defense is wasp spray. And I think that's probably illegal because it will physically harm you.
There's actually a little thing on the back of every bottle of wasp spray. It is illegal to use this item in a manner not licensed or approved by federal law under the FDA approval of this item. Now, if I'm in my house and I was spraying that wasp nest right outside last night, I set the wasp spray down on the bedside table, went to bed, woke up to a burglar standing over me, and I grabbed the first item at hand, and oh well, that's what it was. There's a legal doctrine called necessity. It even allows a felon to be in possession of a firearm. For example, if a felon takes a gun from somebody attacking him and uses it in self-defense, the defense of necessity would apply. Actually, our current state attorney here in Jacksonville actually dropped a gun prosecution years ago because of a circumstance where something like that happened, and she was right. She understands the law and she understands that defense. So, but the idea of carrying a can of wasp spray around or staging them throughout your home to use in self-defense, bad idea. On the other hand, pepper spray is licensed exactly for that purpose, and so it's perfectly within the law. So I'm a big opponent of that advice, and I don't know where that idea ever came from.
Yep. That also leads into the fact with U.S. Law Shield is if you happen to use something besides a firearm, your vehicle, a shovel, a rake, if you're out gardening in your backyard and it's an actual self-defense situation, you are still covered. It does not have to be a firearm. Yep. Could be a pocket knife, could be a razor, it could be anything.
And depending on, there's a lot of these other policies out there. There's USCCA, there's Second Call Defense, there's CCW Safe. Mm-hmm. Sean Hannity advertises for them, I think, or did for a while. There's a lot of these plans out there, and some of them make more sense for certain people than others. We partnered with U.S. Law Shield for certain reasons. There's actually an aspect of U.S. Law Shield that I am not a fan of, and I told them when we partnered with them, I'm not going to quit saying it. They use what are called captive attorneys. In other words, with some of the other plans, you pick who your attorney is. With U.S. Law Shield, they tell you who your attorney's going to be. And the only reason we partnered with them was because they agreed that for our members, Florida Carries members, they would have the option to use U.S. Law Shield's attorneys or to hire me if they wish to do so. And that was one of the things that we had to get a commitment from U.S. Law Shield from in order to be able to partner with them, because I'm not a fan of captive attorney plans as a general rule. That said, I'm going to give them a props where they deserve it. They have hired here in Florida, Katz and Phillips, who I don't co-counsel with people I don't personally believe in their reputation, legal ethics, and ability. So they've done a darn good job of who they found in Florida for their captive attorneys. I would not hesitate to use them myself. And interestingly, Katz and Phillips is actually responsible for part of their agreement with U.S. Law Shield is they help U.S. Law Shield vet and identify attorneys in other states to work with U.S. Law Shield. So for that reason, it gave me more comfort that Florida Carry could work with U.S. Law Shield despite that provision that I don't necessarily agree with and generally would be opposed to. There are some plans out there that will only pay for your defense after you've spent the money and been acquitted. That's worthless. If that's what the plan's doing, it is not worth a penny. Because I can tell you, number one, I'm not allowed to take cases on contingency of their criminal defense. The bar will disbar me if I say, hey, yeah, I'll work on your criminal case and defend you and wait to get paid from that other company when I get you acquitted. If I do that, I'm not going to be in your case long because I'm going to have a bar complaint and be disbarred. And there's nothing that's more valuable in my realm than my law license right now.
I'm sorry, I have a question off the subject. Do you ever hear of a Unified Sportsman of Florida?
Okay, Unified Sportsman of Florida is an organization in Florida that's run by Marion Hammer.
Right.
Marion Hammer's former past president of the NRA. I consider her a friend and a mentor and an amazing, wonderful lady. She does great work in the state of Florida. We would not be where we are today without the great work that she did, going all the way back to the 70s.
You know, I joined her organization a year ago, and they said they were gonna send me emails and stuff like that. I never got a thing from her.
Well, I don't know how you kept off her list, because I'm on her list about 3 or 4 times. I get every email she sends multiple times.
I've never got one.
That's amazing. I will tell you, so USF is actually basically the Florida arm of NRA. Very similar to, in New York, it's the New York State, and in many states, it's the New York or Texas or Illinois State Rifle Pistol Association. The NRA has these affiliate organizations in many states. In Florida, it's USF rather than being the Florida State Rifle Pistol Association. I can tell you, so the NRA, for all the good work that they do, there are some distinctions between Florida Carry and the NRA that I'm very clear about. Number one, the NRA spends a lot of time focusing on hunters' rights, protection of access to lands for hunting rights. That is not a Florida Carry issue. We're not going to get involved in it. It's not where our focus is. The NRA focuses heavily on self-defense with a firearm. So does Florida Carry, but Florida Carry also addresses and has addressed issues regarding where you can possess a stun gun or a taser. We would get involved in a case that would involve mace or pepper spray. NRA does not always do that. And that's not a criticism, that's merely a function of who are their members, what are their goals and directed activities under their charter, and we just have a different charter than they do. But you know, look, they're the 800-pound gorilla. They've got money that Florida Carry does not have. They've got money to hire attorneys that they pay up front. I will tell you 99% of my litigation work for Florida Carry is done on either a pro bono or a contingency basis. Kevin said we're an all-volunteer organization. That is not exactly accurate. There is one person that has ever received a dime of compensation from Florida Carry, and that's me. They do pay for my time when I go to do lobbying work in Tallahassee. And I will tell you that they are getting a bargain rate compared to what most lobbyists do charge. Some people might say they're getting bargain service too because of the difficulty we've had with some of our senators of late. Senator Flores out of Miami would be one example. But you know, the reality is we fight these things really hard. We do everything we can to advance the right to bear arms and the right of self-defense in this state. And they operate on a shoestring budget, and they are very, very careful with how they spend their money. And again, I do most of the cases on a pro bono or contingency basis, meaning they don't have to pay for it, the other side pays for it. That was true in our case against the city of Daytona Beach, city of Gainesville, the city of Tallahassee. I was not paid on. I never received a dime other than reimbursement of money I had to pay for filing fees and court reporters and things like that. So you know, I do a lot of this work because it's passion. It's something I believe in. I do have to feed my family with it sometimes, but it really is a labor of love, and I love doing it every day. It makes it worth coming to work for sure.
But if that doesn't speak volumes on who you are as a person, Eric, and the true believer you are of the cause, I don't know what does.
We probably have a time for another question or two for Eric or Kevin. Just a reminder, if you've got a question, I did mute 4 different people just because of background noise. So if you're trying to ask a question and no one's replying, see if you haven't been muted, and you do need to unmute yourself. Thank you.
Anybody have a question?
And I'm actually free to run a little bit long if y'all want to.
Rolly, you look like you want to ask a question. Do you or don't you?
No, I have no question.
Okay, well, then I have a question then. Do you know Representative Sabatini?
Yeah.
Yes, sir. I do not know him personally. I've had phone conversations with him in the past and with his staff. He is what I would say, I'd say he's like me. He is a true believer in the right. I am concerned because in the past, sometimes true believers in the right have been squashed by past Republican Senate or House leadership. You know, Representative Sprawls, who is our new speaker, incoming speaker, I believe is I don't know if he merits what I would call true believer status, but he certainly has indicated his support for the right to bear arms and the rights of Floridians to act in self-defense. This upcoming session is going to give us an opportunity to see if he holds to that commitment and what he does. I mean, he's got a perfect opportunity right here, right now in this session to stand up for the right. You know, Representative Sabatini can be he has not demonstrated that he wants to work within the system that the legislature has always worked within, and that's not necessarily a bad thing. He's taking them to task, and he's calling names where he needs to.
I got an email from GOA, Guns of America, yesterday.
Mm-hmm. Yes, sir.
That says that he's going to be coming out with a couple bills that we're going to like. It's HB 6001 and HB 6005. But it wouldn't say what the bills were. It just says you're going to like it. And
let's see if they're in drafting and available yet.
It's I guess it's supposed to make us go back to the gunshine state instead of the sunshine state.
I believe one of those bills, I may be wrong, but I believe one of those bills are a constitutional carry bill.
All right, I have 6001 here, and let me get 6005. Okay, so 6001 will amend section 79006, which is the concealed carry statute. And what it says is just the summary, to delete provision prohibiting concealed carry licensees from openly carrying a handgun or carrying a concealed weapon or firearm into a college or university facility. So it would get.
You could carry on a camp. If this passed, you could carry on a campus then.
Yes, sir. This is a campus carry bill.
Okay.
Which Florida Carry wholly supports and has been advocating for years. He also, the 6005 is a bill to repeal or get rid of 870.044. That's the statute that a lot of cities and counties like to use to try and shut down gun sales when they declare an emergency. In other words, oh, well, sorry you need a gun right now, but we're not going to let you buy one. You should have done it earlier. I'll agree with him. You should have done it earlier, but I don't agree that the state ought to be, or city or county ought to be prohibiting you from getting one when you suddenly realize the immediate need for it the most. You know, whether or not those bills will pass, I can't say. I can tell you Florida Carry will be supporting them. As they are currently drafted, we will be supporting those bills.
Very good.
Or another version of them that somebody else files that does the same thing. You know, we believe in this. Interesting little corollary. You know, the Attorney General is currently telling us, and she has to defend state law, prohibiting 18 to 20-year-olds from purchasing. She doesn't have to use mouse brain experts to try and do it. But, you know, she tells us that 18 to 20-year-olds aren't capable of bearing arms safely. Okay, fine, Mr. Attorney General. What about 29-year-olds? Because the reason I say that age is the average age of students in our state college system. So we have the university system, UF, FSU, USF, those are state universities. Then we have the state college system here in Jacksonville. That's Florida State College at Jacksonville. I don't know what these are the former community colleges, used to be junior colleges. The average age of a student at those schools is 29 years old.
Wow.
A lot of them these days are there on a GI Bill, meaning they've already served this country and had the right to bear arms in defense of this country. Tell me again why that person with a concealed carry license is not capable, competent, and able to carry on a college campus.
Because they're ex-military.
Well, okay, fine. Tell me why I'm not able to. What is it that you are worried about me doing, law enforcement? And unfortunately, y'all, I'm going to tell you, I imagine there's a lot of people watching this who are probably have back the blue tags on their cars or stickers, who will tell me that they are great supporters of law enforcement and those type of statements. I'm going to tell you that one of our hardest opponents in Tallahassee, the people that I spend more time fighting in Tallahassee than I spend fighting Democrats, anti-gun Democrats, is anti-gun sheriffs of the Florida Sheriff's Association. Out of the 67 sheriffs in this county or in the state, I would say that not more than 10 truly and completely back your right to bear arms. That's what I've seen by their statements in Tallahassee.
Ours does here in Marion County. Believe me, he's all for everybody to have a gun.
All right, Mr. McConnell, I'm going to challenge you on that statement.
Okay.
And here's why I'm going to challenge you. He is currently I'm not sure if it's been filed yet. If it hasn't been, it has been filed. Okay. He currently has filed against him a lawsuit. That lawsuit alleges that his deputies walked out to two men who were doing nothing more than walking down the street with holstered firearms or slung rifles, carrying fishing poles, headed to go fishing, and his officers proned them out on the ground and detained them for what is a legal act. It is perfectly within the law. An an internal affairs complaint was filed against those officers saying they should not have done this.
Okay.
He has chosen to back his officers. he has decided that these officers did nothing wrong and that their behavior was completely appropriate, and he is now being sued for it. So if he wants to tell me that he supports the right to bear arms, then his officers ought to be better trained than to point guns at law-abiding citizens who are doing nothing more than walking down the street with a lawfully possessed firearm.
I agree.
That's-
When did this take place?
Kevin,
We
can you
aren't
tell me
aware
the
of it.
date?
Pardon me?
Say that again, Eric?
Can you tell me the date
Sure, September 29th,
of
last year.
2019?
Yeah.
And I will tell you that, and he cannot talk about it because it is pending litigation that he is a party to, but the individual that was proned out, one of the two individuals proned out is Mr. Sona.
Really?
Yes, sir.
Yes, sir.
And the funny part about this is we had held multiple open carry events prior to this in the city of Ocala, Florida. And these were off-duty sheriff's deputies who actually, I have the video, said, well, you're carrying within 1,000 feet of a church. There's no law in Florida about how close to a church you carry, nor is there any law in Florida about carrying in a church.
I didn't think so.
So, but that's okay. I just had a police officer in a deposition the other day tell me that you're not allowed to carry in a bank either. He also told me that you weren't allowed to carry in government buildings. Another one of those police officers told me that it is perfectly appropriate for law enforcement to point a gun anytime a citizen is carrying a gun, because they don't know if that person's a felon or not, and that they believe they have the right to detain that person to find out if they're a felon or not. Even though the First District Court of Appeals has said that is not the law of this state, and the Florida Supreme Court has said that's not the law of this state. And you want to make it really scary? These police officers have concealed carry licenses. What that means is, just like you, they have sworn under oath to the state of Florida that they have read and understand all the provisions of Chapter 790 of Florida Firearms Law. But yet they make these statements. We've got a fight ahead of us in the legislature. If Mr. Sabatini's
Sounds
bill
like it.
passed, if we're going to have other bills passed, it's going to take people like y'all who know your sheriffs, who have had contact with your sheriffs, who attend your sheriff's meetings. When the Florida Sheriff's Association, the association representing them, shows up in Tallahassee and says, we oppose this bill, their members of that association need to hear from citizens in their county, the citizens that vote for them, and ask, why is your association spending money to go to Tallahassee to fight against my rights? Why, Mr. Sheriff, my tax dollars that pay your salary and that pay your budget that then funds the Florida Sheriff's Association, why are you using my tax dollars to fight against my rights? And why do you tell me you're pro-gun when your association's in Tallahassee opposing my rights? And until that happens, the Florida Sheriff's Association will continue to fight against the rights of Floridians. Now, I'm going to tell you a couple of exceptions. Wayne Ivey in Brevard County, we have no truer friend in the Second Amendment in the Florida Sheriff's Association. He's been fighting tooth and nail for us. There was a Nick Finch in Liberty County. He was fighting tooth and nail for us. Gordon Smith in Bradford County up near Gainesville. He's been fighting tooth and nail for us. They're the ones, they need the credit. That I like to name them when I start talking about this, because we got at least 5 and maybe 10 in the organization that I would say are true Second Amendment believers. They're being shouted down by the other 56, 57, whatever it is. But we need to support those guys, and we need to call out the sheriffs in the counties that are saying, oh, I support the Second Amendment, I'm a great defender. But then when the Internal Affairs gets a complaint about their officers, they go, well, what were we supposed to do? I understand the police department needs to support its people. I understand their need to make sure their people are safe. But as I always say, people say officer has a right to go home at night. Absolutely, he does. But is his right to go home at night superior to the law-abiding citizen who's lawfully carrying a firearm? Are his rights somehow more important than that citizen's? We've had multiple shootings around this state where police officers have mistakenly shot law-abiding citizens whose only crime was to open the door at 1 o'clock in the morning to a police knock with a gun in their hand. Well, they didn't know it was a police knock. They didn't have a peephole. They didn't have a window facing that door. And so when they open their door, their gun is down by their side in their hand, and they open the door, and the police officer sees it and starts shooting. Well, officer, why were you there? Well, a neighbor told us that motorcycle, which fits the description of a motorcycle involved in an armed robbery 3 weeks ago, belongs to that apartment. Wrong apartment. So even if the motorcycle fit the description, they didn't send it to the right apartment. Not the guy involved in the armed robbery. He and his girlfriend are doing nothing more than hanging out playing video games or watching a movie. I forget what about the circumstances of that one. But a knock at 1 a.m. and he opens the door and the officer sees a gun and shoots. Was the officer scared? Sure, I get it. Does the officer need to be prosecuted criminally for it? Probably not. This was not an officer that was acting in a criminal manner. Should the state of Florida or that county at least have to pay damages to that family for the loss of the breadwinner, for the loss of income of that person? Absolutely. What did the court say? Nope, sorry, qualified immunity, no obligation. Sorry you lost your dad. Sorry you lost your husband. Sorry you lost your boyfriend. Sorry you lost your son. No damages, no compensation. You're done. And that's wrong.
Doesn't seem right.
So, yeah, I'd love to see Florida have a civil rights statute similar to the federal statute, but it doesn't give qualified immunity that says, look, bottom line is that money's not coming out of the police officer's pocket anyway. It's going to come out of we the taxpayers' pocket. But if we're going to send people, call police officers out on the streets to try and get the bad guys, in any other business, when your employee screws up and hurts somebody, and you put the employee in that position to hurt that person, you're responsible and you have to pay the damages for the harm that employee caused. And I don't think there should be a different rule when it's the state or the city doing it versus anybody else. The state already has caps on how much they have to pay out, okay? Those caps may be appropriate to protect the taxpayers. But the fact is, if your taxes started going up every year because you actually got held responsible for what police officers do in our communities, I think a lot of us would be paying a lot more attention to what the police officers are doing in our names and how they're doing their jobs. I don't want to put them in danger, but nor do I want to put our average citizens in danger. I don't want to be in danger. I don't want my family in danger.
We used to go and notify law enforcement, local law enforcement, if we were holding an event, for holding a fishing gathering, or just any gathering where we were going to be, just as a respectful notice. We had a situation where here in Ocala where we were holding an event at Tuscaloosa State Park, and I literally posted the event about 10 p.m. the night before. 7:30, 8:30 the next morning, my phone rang with the detective from OPD, Ocala Police Department, asking me what was my intentions with the event. I went over them, and then they proceeded to tell me that it was illegal for us to be in the park, to fish in that particular park between the ages of 16 and 65, if I remember correctly, Eric. So they literally tried a department that claims to be pro-gun, pro-constitution, pro-self-defense.
And that was the police department, not the sheriff.
Police department, correct, Ocala PD, who proceeded to try to shut us down with, basically my words would be, what would we call that law, Eric? I'll let you.
It was a Jim Crow law. It was a law. It was a city ordinance that Ocala passed to keep black people from fishing in Tuscaloosa Park.
Between the ages of 16 and 65.
It was passed about the same time as the integration of swimming pools. Some of y'all may be old enough to remember when a lot of cities and counties shut down their public swimming pools because the pools were ordered to be integrated. They could not segregate swimming pools anymore. This ordinance was passed about the same time as those events in the 60s.
Wow.
And it wasn't being enforced anymore in that way. I tell people all the time, our current license, our concealed carry law that we have in Florida today, it was originally passed by the Florida legislature as a way to prevent, and I'm not kidding about this, this is in a Florida Supreme Court decision, to prevent the Negro populations of the turpentine and lumber camps from bearing pistols and Winchester repeaters. That's where our licensing, our gun licensing or concealed carry licensing law in Florida comes from. Now, it was modified in 1987 by Ms. Hammer for the purpose of making a uniform statewide process for the issuance of that license to keep it from being a political thing by individual sheriffs like they were using it. And I don't know that even Ms. Hammer, because she's not old enough to know the Florida legislature did that in 1892 is when that, or 1893 when that happened. But I think, yeah, honestly, she was trying to get us a licensing law that was uniformly applied and would allow everybody to conceal carry in the state. But the reality is that's why we have a licensing law in Florida, and why there was one for her to modify in 1987 is because in 1893, the Florida legislature passed a law to require a license so that they could get around the 14th Amendment and continue to deny a person the right to bear arms in the state if they happen to have darker skin color.
Yep. And I bring that up to the fact where, again, it goes to where Eric spent approximately 2.5 to 3 weeks, if I remember that correctly, basically working with OPD and the county to make sure they understood they are violating our members' rights. And so it just goes, I'm going to the fact where that stuff isn't public knowledge. I believe this is the first time I've spoken about it, basically publicly, because we just kept it in-house. It didn't have to go that way. It got settled. It got, fixed. But that's the same exact park where I was held at gunpoint, where we put 300 people in that park yearly. This was the first year. This past April was the first time we didn't hold an event due to the whole COVID thing going on. But I definitely never expected to encounter resistance like I did walking into that park that one day just to go fishing. So.
We learn something every day.
Yep.
Anybody else have a questions? I guess it's probably about time to wrap it up.
Yeah, I do have to go. I've got another meeting to get to. Gentlemen, I thoroughly enjoyed it. If y'all would want to have us back sometimes, if there's members that say they couldn't ask a question or had questions about Florida gun law or what we're doing lobbying, especially as the legislative session starts in January, I'd love to come back on and let your members know, hey, is your sheriff one of the ones in Tallahassee? Or is your sheriff's association started doing the right thing this year? Because I can tell you in the next few weeks, and my suggestion to you, you got these 2 bill numbers. I suggest if y'all want to, I wouldn't say call flood them, but Barry, if you want to call your sheriff, tell him about these bills and ask him, is he going to support them? Or if he says, yes, he is, ask him if he's going to make sure the Florida Sheriff's Association supports them. And if he tells you, I don't have control over the Florida Sheriff's Association, say, well, okay, that's fine, I get it. But y'all take votes on what position you're going to take within your organization. How are you going to vote within your organization? And hey, by the way, I want proof that you voted the right way. When y'all take those votes, let me know that you're the pro-gun sheriff, and you let me know who your other pro-gun sheriffs are that vote to support this, and which sheriffs don't vote to support these bills. Because I can guarantee you, they are going to pitch a fit over 6005. They love that power. Because, power corrupts, and absolute power corrupts absolutely. Unfortunately, our sheriffs love that power to shut down things they don't like when they don't want them happening. And if you don't think they're going to use it to shut down the next gun show that they don't like, because that's what they tried to do even after Parkland. They tried to shut down gun shows after Parkland. They're going to use it for everything they can use it for, and especially the really anti-gun ones. So we need the ones that claim to be pro-gun. We need their support, and we need their help to make sure the legislature puts this in place so that their anti-gun brethren down there in Miami and Palm Beach and Broward don't have this tool to misuse against us and against our members down there. So yeah, go ahead and call him. Yeah, Barry, go ahead and call him today. Ask him about these bills. Tell him you expect him to vote for the FSA to support these bills in the legislature. And I can tell you right now, he's going to tell you what a great Second Amendment supporter he is. But I also got a feeling he's going to tell you, well, he just doesn't really have any control over it. And that he can't vote to take away the power to shut down gun stores during an emergency. That's my bet. I'd love to be wrong. Please let me be wrong.
Well, thanks, Kevin and Eric, for coming today. We appreciate it. And we probably will have you back sometime, maybe in person. That would be even better.
I would love to even be down. If y'all are in Marion, I will be there in the coming months once we are allowed to do in-person things again. So yeah, I'd love to do that.
Very good. Anybody
Okay.
got anything before we close? All right.
Well, I'd just like to say first time, and it was a very enlightening discussion.
Very good.
Y'all have a great day.
That's our newest member.
Oh, awesome.
Awesome. Yeah, I would just add real quick, if you guys are interested in joining Florida Carry, you can go to floridacarry.org, sign up, join that. If you're also interested in a U.S. Law Shield membership, they offer a 50% discount for Florida Carry members to join. So
Already a member of that and your group too.
thank you. We really appreciate it. We can use all the help we can get.